All right, welcome back. So we are looking at the end of chapter 8 this week and the end of the material for this course, actually, which I'm sure will be of great disappointment to you. We'll look at Aboriginal title next week, that being obviously entirely, I won't say optional, but certainly supplementary, and won't be tested on the exam, of course. So that's it. I'm sure it's been your favorite course, certainly the easiest of your first year, and if not, hopefully I made it as fun as it could be. So we're finishing up non-possessory interests this week. You'll recall we started last week. We started with profits of prandra, and then we looked at easements. We said easements are essentially a right having to do with someone else's land. Right? It's considered to be a property interest. It's relevant in that it's a relationship directly between land and land, right? Distinct from other types of property interests that we saw, which were between people and things. Right now it's between things and things. The distinction there being relevant in that it is permanent. Because it's between things and things, it's not extinguished upon the death of someone, right? And it unites two pieces of land in a way that persists over time, regardless of their owner. And it's also why there's a requirement that it be related to the land, right? As opposed to the actual people using the land. You'll recall on that, we saw the Allensborough case, the Allensborough Park case, where you had this park, which was being used by a bunch of houses on a street, and then the question arose as to whether or not they had a right to keep using the park. And that would have been relevant because if not, right, it wouldn't have been a property right, and you could have destroyed the park, right, and create something else there. Whereas if you have a right to the park, and the right is of a property nature, for the reasons that we saw, the consequence of that is that it persists over time and in fact essentially permanently, right? It essentially by default persists permanently unless it's abrogated by either statute or by mutual consent. So we started looking at easements last week. You'll recall we said a couple times that we kind of left off in a weird place, which was important to remember. So we looked at the first two criteria for easements last week, right? First, you had to have a dominant and a servant piece of land, so two parcels of land. Then second, right, had to accommodate the servant piece of land, had to accommodate the dominant piece of land, right? So for example, you have a right to cross your neighbor's land. Well, the fact that you can do that, right, is a burden to your neighbor's land, and it accommodates your own. Now we look at the three other criteria. That's why it's kind of a weird place to leave off, right? Kind of in the middle of the test there. The two additional criteria, which are slightly less relevant. So first, the two parcels of land need to have different owners. We'll see what the relevant of that is. And it has to be able to, right, when the easement is granted, form the subject matter of a grant, which of course in itself reads as meaning absolutely nothing, and we'll see what that means as well. So first you have to have two different owners. Why is that relevant, you ask, right? First, conceptually, the problem is if you don't have two owners, it essentially means that you're defeating the purpose of an easement, because an easement is part of this category we had last week of non-possessory interest, which also encompassed the other stuff that we saw last week. Why was that relevant? Well, what did it mean, right? Non-possessory interest did not mean non-possessory in that you did not have possession at all, right? In fact, conceptually, you don't have possession. You have something else called use. So if you cross your neighbor's land, you're not really in possession of their land. You are essentially in temporary use of their land. Nonetheless, right, you have something that is kind of akin to temporary possession, which is not the correct word, but essentially what it is, right? So non-possessory really means non-exclusively possessory. So possessory means you have exclusive possession in the sense of all the interests in land that we saw. So if you have a lease, right, you have an exclusive right to possession of the leased premises to the exclusion of all, including the rightful owner. Same thing if you have a fee simple, same thing if you have a life estate. In contrast, an easement is non-exclusively possessory. So, you have a right to cross your neighbor's land, right? That's a right that does not give you exclusive possession over the thing you're crossing, namely in that the rest of the time the owner has it. If you have two different owners, the right to cross the land, right, which is a non-possessory interest, and the underlying possessory interest, right, are owned by the same person. And so essentially you can say, and if that confuses you, forget about it, which the book says, right, essentially you have the person who has the right to cross, they hold a greater interest because they also have the possessory interest on the other piece of land because they're the same owner, right? And therefore they have more rights than can be granted pursuant to a non-possessory interest. Another way to say that is that it's completely useless, right? You don't need a right to cross your own land because it's your own, right? You won't complain because you're also the owner of the other parcel of land. So, in that sense, the requirement itself might be useless, but it arises in relevance when, of course, that ends, right? When you say have two different owners, then it's useful to have an easement, and then you buy the second parcel of land, right? And then you seek to sell it now to someone else, either or both. Well, then you have a problem because ostensibly by virtue of the third requirement there, the easement in the meantime, during the period where you were the owner, was extinguished such that now when you transfer it again, it no longer exists. We'll see. That's the only situation where it becomes relevant. And there's been, as you mentioned, statutory 669 statutory changes which don't apply in Ontario. So, third requirement there is a problem because of the trouble it causes in that specific situation. Okay, then you have the fourth requirement, right? It says it has to be able to form the subject matter of a grant, which means absolutely nothing, right? 669, you have a bunch of declinations of what the fourth requirement means, essentially as an appropriate locus for judges to do whatever they want with essentially policy considerations, right? So first, it cannot be too vague. It's something that we saw earlier in the term, right? With restraints on alienation, we said they become invalid if they're too vague, which is essentially a public policy concern. We don't want, right, people not to be able to govern themselves, and we don't want people to have undue, overly limiting limits or restraints upon what they can do with their land, right? We want them to be able to freely use their land. Then it has to not amount to a claim of joint occupation. What's that mean? Well, it means that you have to not grant too many rights to the easement holder. So, for example, a person who has a right of way, right to cross your land. If you give them too many rights, why is that a problem? because then it becomes akin to full possession, therefore ownership, therefore cannot be qualified as a non-possessory interest. And third, right, requirement there 669, it has to be not for fun, but of utility and benefit, which is essentially a declination of what we learned last week. It has to benefit the land, not the specific people. And to benefit the land, it also has to be of value or utility to the land itself, which will generally mean that it is something to do with ensuring that the property is worth more. Okay, then you have a number of cases there, lots of pages in the ratings for this week. But first, the shelf holding case, you have an example of a petroleum line, and the question is, right, are they granted too many rights, right? First, there's kind of a significant possession over where it crosses the land, and then there's rights attached to that. So to come in to make certain changes to it, right? And essentially the case is about, right, requirement number 4, we said, is essentially public policy consideration. One of the declinations of number 4 is, as you'll recall, because I just said it 2 minutes ago, right, the grant has to not be inconsistent with the nature of a possessory interest. So if they have too many rights, right, to have the possession, the temporary possession over a portion of the land, to come in, to make changes, right? If that becomes too significant, it becomes akin to ownership, therefore cannot be categorized as a non-possessory interest, and the court says no, right? The rights there are extensive, but they do not amount to possession, exclusive possession, and therefore, right, something that cannot be characterized as a non-possessory interest. And essentially, right, what that turns on is first, it has to not be inconsistent with ownership. So whatever is left after you take away the rights subject to the easement, whatever is left to the owner of the land has to be not too small that it cannot be categorized as possession or ownership, essentially. And that will mean oftentimes, right, a requirement that you're comparing the two, right? Comparing the rights you're giving away with the rights that the owner is taking. Okay, the easement is created by grant or reservation. I'm not sure if that was ever confusing to anyone, but essentially, right, say you have 2 pieces of land, right, and now there's the street there, and you're cutting it there, which is not smart, right? You should have done it this way, but you did it this way. So this person here, who owns land B, is in big trouble because they can't access the land. So what do? They get an easement over A's land such that they can get out. That is, right, essentially, the 2 pieces of land at first were owned by one person, then you transferred ownership over, so say you keep B, right, you transfer ownership over A, but you retain over A the right to get out. That's by reservation. So you used to own both, you used to own A, and you transferred A, but you transferred it subject to your right to cross it, which was reserved. That's reservation, right? and you can have the opposite situation happen, which is by grant, right? So if you transfer the B portion there to someone else, you keep A. It's no trouble for you because now you have the street, but the person who buys it also needs access to the street, and so you grant them, magic word there being grant, an easement over your land such that they agree to buy it, and that is by grant as opposed to reservation. That's at page 674. Okay. If you are creating this, in writing, which will almost always be the case, right? Usually the way these mechanics happen is either you need to create them to be able to sell your land. So there, right, you'll never be able to sell parcel B to anyone unless you give them a right of way over parcel A. Say you own both, right, as in my earlier example. No one will buy it if they can't get to the street. So you give it to them because you have to, and usually they'll want that to be in writing and registered, right, so that their land doesn't become worthless if someone later claims that that right never existed. Either way, you do it in writing, you register it. The other way this can happen is you buy it, so if it's a benefit, right, if you don't need to cross the land, but it's benefit for you because, right, it makes your life easier, then you'll call up your neighbor and you'll say, I want a right of way. Usually the reason why people give away rights is because they get money in exchange, right? Either way, you'll have that in writing and in the registry to the extent that it is a property interest, which it is. It is a non-possessory interest, but it is nonetheless a property interest. In fact, by definition, the easement always is a property interest. Again, as we said at the very beginning, of a different nature in that it is between two pieces of land as opposed to a person and a piece of land, nonetheless, because it's a relationship with things involved as opposed to just people, it is a property interest. So it's a property interest, means you can have it in the registry, also means that you're subject to the statute of frauds, and so you'll have to meet whatever requirements there are, right? So by default, property interest, right, common law doesn't say anything, but you can have additional statutory requirements, as we saw last week, right, which impose additional, essentially, evidentiary requirements for there to be either registration and or, right, a piece of writing evidencing the transfer that you're claiming to have happened. And usually, again, right, it will most often be an express easement because it's serious enough for you to get a piece of paper to make sure it doesn't go away, or because you've bought it, in which case, again, right, you don't want to lose your money, so it's serious enough for you to get a piece of paper. Okay, you can also have an equitable easement to the extent that you don't do it this way. So, again, same thing as the doctrine of part performance. Equity comes in to save people, right, with a bit of justice when they haven't done their homework and called their lawyers. So, you can have that if you have, right, a verbal transfer, which is invalid by virtue of the statute of frauds, not by virtue of the common law, not by virtue of property law, by virtue of statute of frauds. Simply because there's a law that says it has to be in writing, now it has to be in writing. It's not valid. So you do it verbally, what happens? It can be an equitable easement to the extent that you have essentially everyone acting as though it happened, and it will still count as an equitable easement. You have an example in the book of the guy with the highway, right? They build, I think, a ramp over the highway so he can get, I think, his cows to cross or something. And then, right, when they do build the highway, and then, right, mean government tries to take away the ramp, says you never had a right to that in the first place. Well, it was in that case, of course, not express because no one wrote it down. it was implied and it counts as an equitable easement because there's been the stuff that we saw under equity. So first, something like performance and or something like reliance, right? So the guy would not have let the government build the highway there in the first place if he knew that one day they would take away the ramp, which he only needs because they just built the highway there. Okay, you can also have an implied easement. Okay, so you probably gave up on my handwriting getting better by now, since there's only 1 week left in the semester. What's that mean? Well, it means that it's essentially by virtue of necessity, the traditional example being you are landlocked. So say you don't have my thing there where, right, someone splits it and sells it, right? Say you just buy land B, right? And you know, you get from someone who used this boat because there's a river here. And that person does not own a car, they get to their home by boat. And they've done that for 100 years, but now you're you're someone else, and it turns out you don't have a boat and you much prefer using the street like everyone else. You are what we call landlocked. You are stuck in your land and have no way to get out to the public facility that is the street. Well, to the extent that that's the case, right, you're screwed. And because of that, we will imply by necessity a right-of-way for you to cross over A's land and get to the street. And obviously the criteria for that are strict. First, it has to be necessity, right? You have the case there, page 676 and 7. Has to be necessity. We'll see that doesn't mean absolute necessity, but means practical necessity. So in my example, right, yes, you could have bought a boat to get out of your land, and technically you could have, right, use that to get to work every day. Therefore, there is no absolute necessity because there's a river. Nonetheless, there is practical necessity because the vast majority of people do not use boats to get to work. So that's what we mean by necessity, practical necessity. Second, it's rare because it's free. And the government doesn't like to mandate people giving a right over their properties. In that example A, giving up a right over their property, allowing B to cross it, right? Government mandates that, or the law mandates that, for free because it's by necessity, and therefore we interpret that as narrowly as possible because we prefer for people to get compensated if they lose their rights. Okay, we will do some erasing there. Before we do 681, I'm not going to get into all the details of this. Certainly you've done the readings, not all that important. 679, implied easement, gets back to the stuff we saw, can be created equitably without formalities. Then it becomes a matter of whether it's also valid at law and can be registered or not, right? Significantly though, to the extent that an easement is implied to be 681 for a specific purpose, it can be invalidated subsequently when that purpose is no longer met, when it's no longer necessary. So you need it for a reason. If that reason disappears, I don't know, because they build a street there, for example, right? then, right, it's possible that it might be invalidated, and that would be true regardless of whether it's created by impliedly or expressly, right? You can also agree to an easement, which implies a condition that is for a specific purpose, and if that purpose disappears, right, it would no longer be valid. Okay, you can also have an easement by prescription. And you'll recall that we saw that under essentially adverse possession, right? So there was a lady who, and all this makes sense now, it probably was extremely confusing a month ago, right? But there was a lady who crossed the land, and then, she did that repeatedly without the consent of the rightful owner and without hiding. That's what the criteria are under adverse possession. We'll repeat them shortly, but essentially that's what they are, right? Peaceful and without consent. So the lady crosses the land, right, for a long enough period of time for her to acquire a right by virtue of adverse possession, which you'll recall was a way for people to acquire land, right? So you had the lost objects, which you could acquire over time. That was possession if they wrote a title, and time in between gave you full title. We said use the same stuff with land. We said you know it's not yours when it's land, and in fact you also know, unlike for a lost object, right, you know whose it is, because there's a registry that says so. So it's essentially then possession that's adverse to the rightful owner, because you know who they are. And you disrespect that by staying on their land, right? Eventually you acquire, again, title by virtue of possession. Possession plus time. So, the lady got to cross the land over a long enough period of time for her to acquire something. Then she went to court and said, I want ownership over the stuff that I crossed. And the court said, no. Because the nature of the action that you took did not exhibit sufficient possession for you to acquire title pursuant to adverse possession, because for you to acquire title by virtue of adverse possession, you need to exhibit possession that is inconsistent with the rights of the rightful owner, which means you have to exhibit possession as though you were the rightful owner, which means exclusive possession. So, lady crosses the land, this is not it. But, the court said, she can acquire something else. She can acquire a subset of that, which is the right to cross, which she did exercise with sufficient use, not to use the word possession, right, inconsistent with the rights of the rightful owner, who also has a right for the lady not to cross by default, right, and therefore he's lost that right. And all that was confusing. Now it's not, because you know it's an easement. It's a right of way, right? So, all that to say, you can acquire by virtue of prescription, as you did with adverse possession, a property interest of a nature other than title, namely an easement, which is a non-possessory interest. For that reason, you will meet the same criteria as you did pursuant to adverse possession, which I'll repeat shortly. Okay, and again here, the government and the courts will interpret that narrowly, because again, it's without compensation, right? So, the lady. There would have been a way for us to pick up the phone and say, here's 10 grand for you to allow me to cross the land, right? And the neighbor could have said, yes, thank you. She didn't do that, right? Therefore, she's trying to claim adverse possession, so it's interpreted narrowly for these reasons. Okay, so you have the long word, caminas. I knew I was going to mess it up. Cascades, there. Which doesn't say much, but it does say what the statute is in Ontario. For there to be an eventual ability to get an easement by virtue of adverse possession. 685 is where you have the magic words. I won't write them down, but it's important. And they are the same as you had for adverse possession. So it has to be continuous. And this will all certainly come back to memory there. Continuous. So for the prescription period, which was 20 years for adverse possession. Continuous, that meant if you interrupt the nature of the exclusive possession for 1 day, then the period starts running again. The 20 years starts running again from 0. That's what continuous means. Uninterrupted, synonym because lawyers like that. Open means you're not hiding. Because if you were hiding, it would be inconsistent with the principle of notice and inconsistent with, right, you showing something adverse to the rights of the rightful owner. Peaceful means you're not violently excluding the rightful owner, because we don't reward that, and without permission. The two important things there are not hiding and without permission, and continuous. So the Caminas Cas case says what the statute is in Ontario. That is, either way, that is defeated by consent. So if the neighbor says, right, I am giving you permission to cross my land, as opposed to you just doing it without asking, then there is no way for you to acquire anything by virtue of prescription. And that's also by virtue of the fact that tolerating someone doing something is not inconsistent with full ownership, right? If you hold a barbecue, you let people onto your land, it doesn't mean that suddenly you've lost the exclusive possession that you're supposed to display as someone who has title. It just means you invited people over for a barbecue. Same thing there. You can allow your neighbor to cross your land to the extent that you control that, right? You retain the ability to say, well, now I no longer do. Get away, or I'll call the police, right? Then it's not inconsistent with your full possession. Therefore, the person can acquire nothing. It's also why it's part of the criteria. If you have consent, it's not, quote, without permission. Therefore, you don't acquire anything. So, under the statute, you have 2 periods, both of which are defeated by consent, because consent is or the absence of consent is one of the criteria. For 20 years, you can defeat consent in any way, including verbally. So, if you say, I allow you to cross my land verbally, it will be hard to prove. To the extent that you prove it, 20 years. However, past the 20-year period, you can only defeat the attempt to acquire an easement by prescription with a piece of writing that proves consent and therefore defeats the easement by prescription. That's essentially what the case in the statute says, right? So after the 20 years, you essentially lose the ability to prove it by virtue of, say, a verbal agreement. And again, 685 is where you have the criteria just down the middle of the page. And interestingly, right, and this is just me ranting there, but we said some of them are rare because the government and the courts assume that you can purchase it. But you have a very interesting question there, a discussion question, right, in the book as to why do we not have statutory reform eliminate all these things? Eliminate an easement by necessity and or an easement by prescription precisely because there's an alternative. And the alternative is you call up your neighbor and you ask them to get the right that you're trying to get by giving them money. And the short answer is, at least according to me, they might not let you, regardless of what the libertarians say, right? By prescription, they might not let you because they're not there. They don't care. They're really rich, they have a lot of land, they just don't look at it. And they won't pick up the phone if you ask for permission. So the only way for you to get it is to just cross it for 20 years, right? In a way that's open, notorious, continuous, all of that. And same thing for necessity, right? They might engage in rent-seeking behavior. If you need to cross their land to get to the street and it's the only way, they might charge a prohibitively high price for that, right? And therefore, you might not be able to acquire it. And an easement by necessity is the only way for you to acquire it. And as a corollary of that, right, might mean that it makes your land worthless if you have to pay a prohibitively high price for it, which is just, right, a permutation of the same public policy concern that underlies both of these. Okay, then you have a discussion of negative easements, and this we'll try not to make overly confusing. You have the Phipps case there from Lord Denning, who's, as the book notes, pretty notorious for causing the natural evolution of the common law to happen faster than it might otherwise have. And he does not do that there. So what do you have? You have, right, two houses or buildings. They're built in such a way that the wall, although it will survive if you remove one of the buildings, will not have been built in a way that's sufficient to have its usual wall nature, and that's precisely because you had a second building. And so, second building is a hospital. I think they destroy it, and then the owner, Susan, says, I had essentially a right for the building not to be destroyed. Again, negative in that. Different error, you're trying to get the neighbor not to tear down their building as opposed to let you cross it, right? From the perspective of the dominant, right, piece of land, a piece of land that holds a right. From their perspective, if they have a right to cross, it's positive, allows them to do something, right? As opposed to negative, which means it prevents the neighbor from doing something. So, Lord Denning says no, right? Lord Denning says there's no such right. And why is that? Because you have an alternative, which is a covenant. And a covenant is different. It's essentially a right of a contractual nature, which, as we'll see, hopefully slightly more simply than is stated in the book, it's a right of a contractual nature, so distinct from an easement in that it's not necessarily related to the land. It's contractual. It's between people, not pieces of land, so it's not presumptively permanent and non-specific in the owner as is an easement, right? And that's an option, right? So, in other words, you could have signed a contract with the hospital that said, we don't let you destroy it. And ostensibly, again, same thing. If you had done that, you would have given them money. Whereas if Lord Denning decides that you have a negative easement, which no one ever knew about, right, then you are essentially creating a right without compensation, right? And the way this materializes itself in the case is that you get to sue the hospital on the basis of that implied right? So it's given without compensation. The direct consequence of that is that you get to sue and claim money for the infringement of that right, which otherwise would not exist. And usually we don't have those, right? You don't have those rights to light, air, a view, right? These are usually things that you don't have a right to by virtue of common law property law, namely because it would be overly limiting, right? It of course penalizes you as an owner, makes your life a bit less fun if you don't have a right to your view, which you might have paid for. But otherwise, you're imposing an undue burden according to common law property, right, upon other people to have free ownership and possession of their own land, and that's something that we generally don't encourage for all the reasons that we saw during the course. And you can always have those created by law, right? So the government can, as it always does, right, first pass a law that destroys an easement. So an easement is, because it's a property right, because it follows the land and not the people, for the reasons that we said last week, it's presumptively permanent and therefore can be canceled, destroyed by either common intention of both landowners or by law. The government can pass a statute, and for all the reasons that we mentioned during the term, the statute prevails, right? The government gets to change the common law, can pass a statute that ousts an easement, and that would, right, invalidate it. Okay, we'll do some erasing there. Okay, and talk about covenants again. What's the nature of that? It's a property interest, but kind of a hybrid one in that it is not presumptively one. It's not presumptively a relationship with things, right? It's essentially of a contractual nature, which so far we said is the opposite of a property interest, right? So it's between people. Why is it considered to be somewhat of a property interest? Because sometimes it can transcend its contractual nature and run with the land, quote unquote. What does that mean? It means bind, contractually obligate third parties. So the nature of a contract usually is that it binds the two people who signed it. Unlike a property interest, which binds everyone, right? So if you buy a piece of land, you have a right to exclude everyone, not just the person who sold it to you. And, usually there'll be formalities for that, the land registry, blah, 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 but it's the nature of the interest. In contrast, a contractual right is between two people who signed the contract. The consequence of that distinction is usually in the remedy that you can get. So if someone breaches their contract, usually the remedy is money, right? Whereas if you have a right to land, you get to exclude people physically with specific performance, not just damages. So a covenant is of a contractual nature, but it's considered to be a property interest sometimes precisely because it can transcend its contractual nature, therefore bind other people than the two who have signed it, and therefore take on a nature that is more like an easement, which is the opposite, right, conceptually, because presumptively an easement binds everyone. Because it runs with the land, it's related to the land, not the people. It's presumptively permanent, unlike a covenant, which is presumptively contractual, only unites the two people who sign the contract. You can remind me if that was too quick, which it probably was, and I'm sorry. Okay, and as we saw, it gets awfully confusing, which hopefully will make it a bit simpler. You don't have to go all crazy over, whether it's positive, negative, runs with the land. We'll try to make it a bit simpler. So, first, a covenant is useful in that it's contractual. That means it's weaker. It's not presumptively permanent, therefore not a threat to the stability of the property ownership system in the same way as an easement. Therefore, we allow for people to use it for much, much broader uses. First, that don't concern the land necessarily, right? Because an easement is permanent because it has to concern the land, right? Like the park, it has to benefit the house, the land, the property, which it unites two of, as opposed to the people, right, in their specific capacity as property owners. A covenant is allowed to be broader, obviously cannot benefit the land, and it can also allow for more significant limitations, right, such as you have in, say, condo buildings, right, which are essentially of contractual nature, much broader and more restrictive covenants or obligations upon land owned by individuals in their personal capacity. Okay, so what is the important stuff there? 696. First, it gets back to all the stuff we saw on privity, right? So you can have privity of contract between two people, in which case it's only between the people, or you can have privity of estate, which is when you're transferring an interest of a contractual of a property nature, and therefore can unite more than the two people who've contracted. That's as much of its relevance, as all of its relevance for our purposes now. At equity, you can have, so at equity, you can have a covenant pass. You can have a covenant, which is an agreement between two parties, unite third parties, so what's that mean? Subsequent purchasers and of both the dominant and servient tenements, and at law, you cannot, okay? And the specifics won't be particularly important. That's essentially because, right, by default, the burden cannot pass. So you can pass the right that is of benefit to a piece of land, but not the burden. That's the default common law position, right, as it developed over hundreds of years in England. Okay, 698, when it touches and concerns the land, what's that mean? It means when it acquires a nature that is broader than the two specific people, therefore broader than a purely contractual interest, starts to resemble an easement in that it's more related to the land and the people who contracted, then, right, it can pass. That's the simpler version, which will be plenty for you guys to learn on the exam. And that's for it to pass, right, at law, not equity, pages 698 and 99. Okay, 702, you have a discussion of, right, some of the consequences of that. Okay, so obviously a corollary of that being a contractual right is that you can have further contractual rights. So one of the assumptions why, right, it doesn't by default pass, first it's not an easement, so it's broader, can be more limiting. We'll see the problems with that in the optional readings for this week. But the assumption also is that you can create a further one, right? That you can have a further contract where you bind yourself. So you buy the land, you bind yourself to the seller, who himself remains bound to the prior, to the other parcel of land, and you have a chain of contracts, each of which can individually be sued upon, and you go upstream. Obviously, that gas, as mentioned at page 702, quite a bit more complicated and unlikely to happen consecutively when you have a significant number of consecutive contracts. Okay, then you have the exceptions to that benefit burden distinction, not important for our purposes. So 704, 705, right? All the details of that are not important. Just remember the stuff I just mentioned on the two important distinctions that we just discussed. By default, though, right, one of the general requirements that can allow for it to pass is when you have notice, which is a permutation of performance, right? So same thing, right? That we saw under a bunch of other things, right? We talked about last week, I think, the good faith purchaser without notice. When you have notice, when you actively accept an interest, right, then it's possible that interest will bind you because you've either acted or consented to it passing. And that's at page 706. Okay, that's it for the readings. You have some very interesting stuff in the optional readings, which I'm sure not that many of you got to because it's already been 40 pages for this week, but you know, it's almost over. And this is actually extremely interesting, right? You have a discussion of the relationship between covenants and discrimination. It's something that we saw earlier in the term, right? We saw that with the guy who created a scholarship trust, and he said, right, it's only going to be white people because I think white people are inherently superior, right? And he said, if we run out of white guys, then maybe it will be a white lady, but only a white lady who's never been married, or if she's been married, has only had sex with her husband. So, right, that was struck down pursuant to broader principles under the common law that were essentially discretionary and therefore essentially made up, right? So public policy was a broad category that could be interpreted as requiring that there be no discrimination, and certain other, right, certainty requirements, which were also interpreted as having the same requirements, and were ways for the courts to strike down something that was discriminatory or otherwise against public policy when there was first no default, no external statutory basis to do so. So no statute that said discrimination is forbidden. And that was also prior to both human rights codes and the charter, both of which prohibit discrimination. So to the extent they apply, it's simpler, but still today they don't always apply, right? Because they apply to public action, that's what the Constitution applies to, and therefore it's a somewhat narrow range of issues. And so you still need either a statute or these broader, right, public policy or certainty exemptions to apply. And you have examples of that, right? Examples of that in the optional readings for this week with covenants, right? Covenants, I said, are broader. They can be used for more things. And that can include saying that, right, you don't want your house or your neighbor to be owned by a Jew. And it's a contractual commitment that you have that does not need to be related to the land, and that can bind, in some circumstances, third parties. And you have examples in the optional readings, which I think are very interesting, of how, right, the courts begun to strike these down because prior to that they were, if not widely accepted, certainly tolerated by the courts, and how the courts used default categories and essentially, right, broadened or invented general provisions under the common law to strike these down. And you have that happening under both, right? The requirement for there to be sufficient certainty and the broader public policy exception. So I would advise you to read it for fun, if at all. I'm sure not many of you will. And that concludes the material for essentially our class. Right, next week is a short and supplementary discussion of Aboriginal title. And that's it for both the exam and common law property.